Hi, good afternoon if you are on the East Coast, and I guess good morning if you're way out west, our friends out in Hawaii. This is Aaron Lacey, and you are listening to ED's proposed Bdr rule. That's the U.S. Department of Education's proposed Bdr rule. A detailed examination, and this is part of the webinar series hosted by Thompson Coburn's Higher Education Practice. I'm going to start while folks are still joining with some housekeeping items, which we typically do. First of all, if you have any questions during the webcast, you can always submit them through the Q&A widget at the bottom of the screen. We have a lot to cover. Today's webinar is sort of a special length here. It's 2 hours. It's a little unusual, but there's just a lot of important content. We will try to get to questions before the end, or if not, we do have some ability to go over just a little bit. If you have a question, again, put it in the Q&A widget throughout, and then we'll try to do a roundup at the end of the show, as they say. A copy of today's slide deck is available in the resource widget, and as I'll talk about a little bit later, we've got a couple of other resources there for you as well today. So please do check out the resource widget. There's a PDF of today's slide deck, and then there are links to 2 additional resources. You can find additional answers to some common technical questions, or rather issues, located in the help widget. This webinar is CLE accredited in California, Illinois, and Texas for 2 hours of general CLE credit, and in Missouri for 2.4 of general CLE credit. The webinar is also CLE accredited in New York for 2 hours of, quote, experienced and transition credit, end quote. We award CLE based on attendance for the entire 120 minutes, so please be sure to attend for the entire time. There will be 4 automated pop-up attendance checks throughout. We're going to display secret words, and there will be a multiple choice poll, and you'll need to click the radio button so that you can demonstrate that you are there and have heard the secret words. So please, 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 if you're interested in CLE credit, make sure that you stick around and you're there to click those radio buttons. If for some reason after the webinar is completed you have any issue with CLE, you can always just reach out to us and we'll work with you to take care of that. After the presentation, we always have a post-webinar survey. We really appreciate the folks who stick around and take the survey. I say every webinar, and I mean it, we read all of the feedback, and we try to use that feedback to make each webinar better than the one before. I mentioned that this is part of the Higher Education Webinar Series being brought to you by Thompson Coburn LLP. If you're new, Thompson Coburn's a law firm, a full-service firm. We have about 400 attorneys, and we're headquartered in St. Louis, Missouri, but we do have locations all over the country in major markets. And again, we've got a group of attorneys who work either full-time or most of the time with institutions of higher education on a wide range of topics. This is part of that Higher Education Practice series. My name is Aaron Lacey. I'm the partner in the firm and chair of the Higher Education Practice, and work with institutions on a really wide range of issues, legal and regulatory alike. We do a lot of strategic planning, governance, work with schools on a lot of complex substantive changes, and spend lots and lots of time thinking about the various rules and regulations and guidance issued and promulgated as appropriate by the U.S. Department of Education. And if you are in higher education, you know this is a busy time. I think we actually have 3 comment periods simultaneously open right now. We've got the Title IX comment period, the comment period for the Bar Defense Rule, and then 2 days ago we had in the Federal Register the publishing of a proposed rule relating to changing ownership in 9010 for the proprietary schools. And all of those comment periods are in play right now, so there is no shortage of things going on. I'm joined today by 2 of my colleagues. One is Jeff Fink. Some of you have heard him before, and we've been worked with him. He did a webinar with me earlier this year on responding to bar defense complaints. And Jeff is a litigator first and foremost, but spends lots of time working with institutions of higher education and litigation, and also administrative proceedings before the U.S. Department of Ed, accreditors, and others. And we're also joined by our colleague, Hope Watson, who's an associate in our higher education practice, does a wide range of things for institutions as well, regulatory, transactional, in administrative proceedings, and other capacities. Here is the syllabus for today's presentation. We're going to just start briefly by talking about the rulemaking status and the opportunity to comment. And that's important because if you hadn't sort of figured it out, the whole purpose of this webinar is not really just to tell you about the rule, although we're obviously going to do that and talk about it in detail, but really to try to provide institutions with a sufficient understanding of the rule to comment, and to also provide recommendations for comment and tools that will assist you to comment. We think it's extremely important for folks in the higher education community to participate in the comment process, and that's always the case, but particularly with regard to this rule, which, as we will discuss later, we think is not particularly favorable for institutions of higher education, and that's a nice way of putting it. We're going to talk about the current Bdr frameworks a little bit for two reasons. One is to make sure you understand where the law is right now, but even more so to sort of understand what the primary components of the claim process are. We think, as you can see their evolution from one period to the next, it also helps to understand what the department's doing now in this proposed rule, which will lead us, of course, a nice segue into the proposed 2022 Bdr framework. Then we're going to get into a global position statement, and that's really just us telling you at 40,000 feet what we think about this rule, and how sort of we are framing all of the comments that we are preparing for our clients and others in our conversations. And then we're going to get into the heart of this presentation. It's just one little bar on the syllabus, but this is about 80% of the presentation, and that's the section-by-section analysis and suggested comments. And we are, by the way, focused on the borrower defense claim process. This rulemaking package included other elements. It talked about discharge on the basis of permanent disability, closed school loan discharge, false certification discharge, and other items. We are really focused on the bar defense claim process, and that's really where we're trying to provide comments and analysis for you all. Finally, we've got a bar defense rulemaking timeline at the end. That's just for you as a reference, and we also have, it's not on the syllabus here, but we have references to some of our other materials, including a link to a similar presentation we did on the proposed Title IX rule 2 weeks ago, which is available live and on demand on our website. So let's start by talking about the rulemaking status and opportunity to comment. I'm going to walk you through these first 3 or 4 sections on the syllabus, and then we'll get to the section-by-section analysis, and you'll hear a lot more from Jeff and from Hope. So just so we're all on the same page, we are talking about the bar defense to repayment regulations that have been promulgated to carry out a statute that was created back in 1993, and it's a pretty simple concept. Congress introduced the bar defense to repayment statute and directed the U.S. Department of Education to, quote, specify in regulations which acts or omissions of an institution of higher education a borrower may assert as a defense to repayment of a federal student loan. So the concept is easy. The department told, or rather Congress told the U.S. Department of Education, you need to come up with a list of things that a borrower could essentially say, my school did this or didn't do that, and so I shouldn't have to pay back my loan, right? In response to that directive, the department promulgated a really concise, brief bar defense to repayment standard back in 1994. Throughout the rest of this presentation, we're going to call that the 1994 rule. And then it followed that up with a very brief clarifying set of guidance in 1995. So fast forward many, many years to the 2016 rule. Following the rapid closures of Corinthian and ITT primarily, the number of bar defense claims skyrocketed. And between 1995 and this point, I've heard different numbers, but it was something like 10 or 20 bar defense claims, if that many were filed. So it was an incredibly small number. And then all of a sudden, we had tens of thousands. And so the Obama administration, in response to that, carried out a NEGREG in 2016, negotiated rulemaking to significantly rise and expand the Bdr framework. They said, look, we got tens of thousands of complaints now. We really don't have any process for adjudicating these claims. We've got borrowers saying that their school did something and they shouldn't have to pay back their loans, right? So the result was a pretty complex process for adjudicating claims that was published by the U.S. Department of Education on November 1st, 2016, which henceforth we will call the 2016 rule. By the way, the links you see in this presentation, when you download the PDF of the slides, these are all live links. So if you want to go look at that Federal Register from November 1, 2016, you can. Also, the timeline at the end of the presentation has links to all of this stuff. And then that Federal Register image to your right, which is what you'll find at that link. You can actually click on that, and that will take you to the Federal Register as well. Something else I want to mention here, which is important because it's going to come up later in this presentation. In January 2017, the Obama administration also published a new recovery process under 34 CFR 668 subpart G. What do I mean by that? So we're going to get into this in more detail, but the November 1 rules, the 2016 rule, put forth this really significant sort of complex process for adjudicating the claims between the borrower and the institution. So that was how the department would make the determination as to whether or not it should discharge the loan if the school did something wrong, right? But then there's sort of this secondary question of, okay, if the department discharges the loan, now does it turn around and try to recover those amounts from the offending school? And it certainly has the, or at least it you know, under statute appears to have the authority to do that. And so what's the process? And what's interesting is in the November 1 and the 2016 rule, the department didn't really lay out anything for a recovery process. And they did that without going through NEGREG, really. They did it in January 2017. Interestingly enough, that rule was promulgated the night before Donald Trump was inaugurated as President of the United States. So it was really a sort of a 12th hour thing that the department put out. And the recovery process they proposed was embedded in subpart G, which already existed, and was the process by which the department carries out termination, limitation, suspension, or fine proceedings. So they sort of hijacked that, hijack's the wrong word, they repurposed that process not only to serve what it was already doing for limitation, suspension, fines, et cetera, but also to serve as the recovery process in the event of a barred offense discharge. The Trump administration didn't like the 2016 rule. So they held a second negotiated rulemaking in 2018 to revise the BDR rule yet again and publish their own version, which henceforth will be called the 2019 rule. Okay, and then in 2021, the Biden administration said, well, we don't like the 2019 rule. We really think this whole thing is kind of a mess. We've got elements of all three of these rules still sticking around in the regulation. So we're gonna go at it yet again. And they initiated another negotiated rulemaking, which took place, at least the live meetings took place in the fall of last year. The negotiators did not reach consensus, which left the department free to create a proposed BDR rule as it sees fit. That's how the process works. If they don't reach consensus, the department's not bound by what the negotiators discuss. And the resulting proposal was published in the Federal Register on July 13th, so about 2 weeks ago, and is the subject of this presentation. So right now, the comment period is open to comment on the proposal that was put forth by the department in the Federal Register July 13th. So you've got 30 days to comment. It's a brief comment period. The deadline is August 12th, 2022, right? So you have about 2 weeks from today. That's why we were trying to hurry up to get all this done so that you all would still have a couple of weeks to digest this webinar and the accompanying materials if you want to. And to comment, we've got here the link to the Federal e-Rulemaking portal, which is where you submit your comments. It's not complicated. I mean, you can write them however you want, you know, convert them to PDF and just submit them, upload them at the e-Rulemaking portal. We also included the reference docket ID for you to make it a little easier when you go there. And you know, we hope institutions will comment for all the reasons we're going to discuss later in this presentation. We think it's really important. Candidly, we do not think that the process that's been put forward here is equitable or fair towards institutions of higher education. And I do mean all institutions, and I want to just take a second here to say, you know, I don't know, somewhere between 40 to 50% of the folks on the line today are private nonprofits and publics, which we deeply appreciate. I will tell you, I still think that this bar defense claim process is largely viewed as a problem for the proprietary and career school sector because most of the claims to date have been filed against that sector. But please, please, please keep in mind that in the future, if claims are filed against private nonprofit or public institutions, and that could be an aggressive plaintiff's attorney away from that happening, this is the process that will be used to adjudicate those claims. This absolutely applies to all institutions of higher education, and we are not hearing a lot of conversation among traditional higher ed about this rule. If you go to NACUA.net, you will see virtually no references to this rule or discussion around comments. If you are in the traditional higher ed space and you're listening today and you get to the end of this presentation and you think, boy, our community really should be engaged, look, send the presentation around, send them the link, send them the memo, the link to that memo that's sitting in the resources tab. But we think it's critically important that institutions be heard, and that's the purpose of this presentation, is to try to make it easy for you to do that if you want to. So speaking along those lines, we've got three things again that we've sort of packaged for you today. One, there again in the resource tab, there is a link to a memo that we wrote, which essentially tracks this presentation, but it's in memo format, right? And it's got links and discussion and background and all those kinds of things. And again, the whole design of the thing, you can see the title of it here is Points of Concern and Suggested Comments for Institutions, right? So it's to make it easy if you're interested. We've also got a comparison document. You can click on this link in the slide here, or if you look in the resources tab, there's a link, and it's a red line we created which shows you the changes and what's been proposed by the department, which can be a little easier, at least for some people, than reading through the Federal Register itself. And then finally, of course, you are very welcome to come back to this presentation and these slides. They will be available free and on demand probably by next Monday or Tuesday. Okay, so let's talk about the current Bdr frameworks, right? There are three. Okay, so I mentioned earlier we've got a 94 rule, a 2016 rule, and a 2019 rule. And what's important to understand is when each one of these rules came along, it did not replace or supersede the prior rule. That's not how the department went about things. Instead, what the department said was, well, we're going to kind of carve it up. And if the underlying loans that are the basis of the claim by the borrower that the borrower doesn't want to repay, if they were prior issued or dispersed prior to July 1, 2017, then the 1994 rule would apply. And if it's between July 1, 2017 and July 1, 2020, the Obama-era 2016 rule would apply. And if it's after July 1, 2020, the 2019 rule and processes would apply. So that's why it's become extremely complicated. You could actually have a student, right, who was enrolled between 2015 and 2019 and ostensibly got loans that fell into all of these buckets. And then, if they had a claim, theoretically, the department might be in a position of trying to apply different standards, right, to three different sets of standards to sort of the same claims, in fact, and the same borrower. It's a mess. There's no question it's a mess. There's also no question that it would be extremely difficult and has been extremely difficult for the department to administer. Let's talk about the key elements of each of these frameworks. And again, there are two reasons I wanted to go through this. One is it's good to see sort of what the current law looks like and the progression and how these things are different. But these elements that you see on the page, scope, claim standards, evidentiary standard, claim process, discharge relief, time limit for claims, and recovery actions. I'll take a deep breath. I know I'm going fast. Sorry about that. That is a common comment that we get in our surveys. I'll try to slow down a little. These elements are sort of the key elements in each one of these frameworks, and these are the elements we're going to really focus on today as we march through the proposals that the department has made. So it's important to understand how they've differed and how the approaches are different, and how the proposal here is impacting these different approaches, okay? So we already talked about scope. When we talk about scope, we just mean, what's the application period, in a sense, of the rule. So the 1994 rule, again, we're talking about applying when the claim being made involves loans that were dispersed for the first time prior to July 1, 2017. What do we mean when we say claim standard? We mean, what is it that's a bar defense? Remember, Congress actually told the department, tell us what acts or omissions of an institution could be a defense for a borrower to having to repay their loan. That's really the main job that Congress gave the department, okay? So back in 94, the department said, well, if it's an act or omission that would give rise to a cause of action under applicable state law. In other words, if whatever the school did would ostensibly violate state law, that's a bar defense claim. That's something that they could assert as a basis for not having to pay back their loan. The evidentiary standard is preponderance of the evidence. In other words, the department is supposed to weigh the evidence and decide whether a preponderance of the evidence indicates that's available to the department indicates that this act or omission did in fact occur. Interestingly enough, the 1994 framework really did not have a claim process or discharge relief concept built into it. I mentioned earlier, it's a really concise, brief regulation. So in 2016, when the Obama administration put their rule into place, they said, not only do certain procedures apply for our 2016 framework, but since the old 1994 framework didn't have these elements, we're going to take the 2016 stuff and apply it for the 1994 framework as well. So even if you've got those old loans that were dispersed before July 1, 2017, you're going to use the standards that applied circa 1994, but the process is going to be the 2016 process. Time limits for claims, there were none in 1994. Basically, a borrower could assert a defense at any time, ostensibly as long as they still had a loan or amounts still owed on their loan. Recovery actions, so, what did the department do back in 1994 if it actually discharged the loan? How did it recover? There wasn't a lot in the law then. Again, this is one of those situations where in 2016, the Obama administration sort of thought about it and filled in the gaps. And so the idea is it would be carried out under Subpart G, right? And the time limit, now there was a time limit on recovery actions in 94, and it was the later of 3 years from the end of the last award year that the borrower attended or any applicable state statute of limitations. So what's interesting is, under the 1994 framework, 20 years later, a borrower could still bring a claim, but it's highly likely that the department would be timed out on being able to initiate any sort of recovery action. All right, so how did 2016 differ? First of all, again, scope is different, right? The 2016 framework standards and process apply for loans first dispersed between July 1, 17 and July 1, 2020. Claim standards. So the Obama administration introduced a bunch more, right? They said this old standard of, it has to give rise to an action under state law is unworkable and difficult. So we're going to introduce some new standards. They said if you've had a prior judgment, right? So if some court of competent jurisdiction said, yeah, we decided in the context of a lawsuit that the school engaged in some act or omission, then a borrower could bring that judgment to the department. If the school engaged in a breach of contract or substantial misrepresentation, as that term's defined at 668.71. So this notion of a substantial misrepresentation already exists in the law at 668.71, and if a school engages in a substantial misrepresentation without regard to bar defense claims, the department could take action ostensibly against that school. Note that the substantial misrepresentation standard under the Obama-era framework did not require any intent on the part of the school. Intent is not baked into that definition of substantial misrepresentation, so it doesn't matter whether the school intended to misrepresent or not. And there was a presumption of actual reliance in group processes. So under the 2016 framework, if an individual brought a claim, they had to establish, if they said, oh, my school engaged in a substantial misrepresentation, they had to establish that they actually relied on that misrepresentation. But in the group process, if there was a group process created or initiated by the department, which was a feature of the 2016 framework, it was just presumed that everyone in the group relied. So in other words, it didn't matter if the school intended the misrepresentation or not, and if it was a group process, it didn't matter if anybody actually relied on the substantial misrepresentation. The department could still proceed with an action, which was troubling, as you can imagine, to a lot of schools. Preponderance of the evidence was still the evidentiary standard. So I mentioned before, the 2016 framework introduced an individual claim process and would permit the department to initiate, certify a group claim process even in the absence of an actual claim by any borrower. So let me say that again. What do you mean, Aaron? What I mean is, even if the department had never received an actual claim being filed, an application filed from a borrower, if the department was driving down the street and saw something in an institution it didn't like that it thought could represent a basis for a bar defense claim, even if it had never received an actual claim, it could initiate a proceeding, a group proceeding, like a class action. And again, I mentioned earlier, if it was based on substantial misrepresentation, there would just be a presumption that anyone in the group actually relied on the misrepresentation. The one sort of, in my mind, saving grace of the 2016 framework was, or a saving grace, if you will, was that if the department initiated a group claim process, it had to be adjudicated and overseen by a hearing official, which presumably would be like an administrative law judge, right? And this is a really important feature because, as you're going to see, the department is proposing now in 2022 to change that, and I think that's important and meaningful. Discharge relief. How do you decide how much to discharge? So there was no requirement that a borrower show actual harm under the 2016 framework, right? And the relief was more or less at the official's discretion. However, in a breach of contract case, it was governed by common law, which would more or less dictate that you would have to determine how much the borrower was harmed and would need in order to be made whole, which is sort of the common approach to breach of contract claims. Time limit for claims, there was no time limit for judgment claims, and then it was 6 years for breach of contract or substantial misrepresentation, subject to when the school received notice. Recovery actions, they were still carried out under Subpart G, and the department could initiate a recovery action essentially at any time if the school had received notice of the claim prior to the expiration of those 6-year time frames. Okay, 2019, what did the Trump administration change? We got all these same concepts, right? Again, scope of the Trump administration framework, we're just talking about it only applies to loans that were first dispersed after July 1, 2020. The claim standards. So the Trump administration threw out substantial misrepresentation as it's defined at 66871. They got rid of breach of contract. They got rid of judgment. And they just had this one standard. It's a misrepresentation standard that they created specifically for the purpose of bar defense claims. And it's at 685-206E3. And it has to be made. So the Trump administration said, well, look, the misrepresentation needs to be made by the institution with knowledge of its false, misleading, or deceptive nature, or at least with a reckless disregard for the truth. So in other words, the Trump administration said, it's not an intent standard, but it's also not a mistake standard. We're not going to hold institutions accountable for honest mistakes, right? It either has to be made with some knowledge or with a reckless disregard for the truth. The evidentiary standard remained preponderance of the evidence. The claim process was simplified, a simplified process for individuals and no group process. Discharge relief, this is a big difference, was based on the monetary loss to the borrower as determined by the department upon its review of the evidence. But what that means is a borrower actually had to demonstrate financial harm. So the department wasn't just going to say, you know, we're not going to assume or guess, you know, you're going to have to demonstrate to us as to what amount of harm you actually dealt with, and then we're going to make you whole based on that amount of harm, right? And specifically, it has to be monetary loss, too. Time limit for claims. So a borrower could bring a claim up to 3 years from the date the borrower was no longer enrolled. Recovery action still under Subpart G. And the time limit for the department to initiate a recovery action was 5 years from the written notice of their determination on the underlying claim. All right, I know that's a lot to process. While you are processing, why don't we go to our first secret word? The first secret word is rule, like a rulemaking. Very clever on our part. Please take this little break time. I'm supposed to give you 20 to 30 seconds is what I'm told by our producer, to click on the appropriate radio button, maybe have a glass of wine or a sip from that martini, and then we'll start talking about what this administration is proposing now here in 2022. I'm going to have a sip of water myself. All right, I think that's enough time. Hopefully you clicked on that radio button next to the word rule. So let's talk about the proposed 2022 Bdr framework. That's what's in this new rule we just received, and that is currently open for comment. All right. So first of all, and Jeff's going to talk about this in detail, the department is proposing a new approach. What they're saying is, you know what, this new rule, both the standards and the processes, are going to apply or would apply to all applications pending or filed as of July 1, 2023. So it doesn't matter when the underlying act or omission occurred. In other words, if it occurred, you know, if the borrower was enrolled 15 years ago and the act or omission occurred while they were enrolled, if they file that application after July 1, 2023, or before, as long as it's pending on that date, then the new rules would apply. Again, both the standards for what constitutes a bar defense claim and also the process. We think there's a pretty serious retroactivity issue here. The department has discussed how they might address it, but we don't think they've done enough, and Jeff's going to discuss. I think that's an extremely important point for comment. I hope everyone will really dig into that, and again, Jeff's going to talk about it in a minute. Claim standards. So they've introduced a bunch. Substantial misrepresentation's been revived and expanded. Substantial omission of fact, which is brand new. Breach of contract is back from 2016. Aggressive and deceptive recruitment is a new concept as well. Favorable judgment is back. Prior sanction or adverse action by the department is also a new concept. In my mind, there are, if you look in the rule, you'll see 5 numbers, but there are really 6 new standards, right? Or 6 standards, I should say, and I would consider 3 of them to be brand new and a couple of revivals of what we saw from the Obama administration. But the key idea here is there are 6 different bases upon which a borrower could assert a defense, right? 6 new claim standards or 6 claim standards. These standards don't require intent on the part of an institution, so there's no consideration for whether an institution intended a misrepresentation or aggressive and deceptive recruitment, et cetera. There's also no requirement, and we're going to hit on this repeatedly, in almost any case that a borrower actually or reasonably relied on the act or omission. So just to be clear, in most cases, and we're going to go through this in detail, it doesn't matter if the institution intended the omission or misrepresentation, nor does it matter whether the borrower actually relied on it or was harmed by it. If that seems surprising to you, then you should be concerned and please pay attention and consider commenting through the rest of this, all right? Evidentiary standard, preponderance of the evidence, still the case. Claim process. So the individual claim process, and there once again is the revival of a group claim process. And again, the group process can be initiated by the department even in the absence of any underlying claims. Both the individual and the group processes would be adjudicated by staff. So remember, under the Obama administration, if the department initiated a group process, that went in front of an administrative law judge. But this administration is saying, you know what, we're not going to do that. Whether it's an individual process or a group process, it'll just be decided by a staffer at the U.S. Department of Education. Discharge relief. This is another huge point. So there is a rebuttable presumption that the borrower was harmed in an amount equal to the entire loan, right? So in this case, unlike with the Trump administration standard, the borrower doesn't have to demonstrate that they were harmed at all because there is a rebuttable presumption that they were harmed to the full amount of the loans that they took out, and they're seeking to get discharged. So unless the institution provides a preponderance of the evidence, sufficient evidence that the department believes that that rebuttable presumption has been changed, then it's just the full amount. There's just an assumption, essentially, that the borrower was harmed in the full amount of their loans. The time limit for claims, a borrower can assert a defense at any time by filing an application. In other words, there is no time limit on when borrowers can file an application. Recovery actions, the other thing that we're going to talk about, it's not on this slide, but there's also extraordinary latitude for the secretary, a borrower, or state agencies to request reconsideration of borrower defense claims that have already been decided. And then finally, recovery actions, that's where the department seeks to recover from the institution. There's no specified process in this regulation. Let me be real clear about that, right? The department talks about in the commentary, we're going to talk about this later in more detail, but I just want to be real clear, the department does not in the regulatory text specify how recovery actions will be managed. It just deletes the old language that sent it to subpart G. They suggest in the commentary that they'll send it to subpart H, but it's not in the regulation. The time limit would still generally be 6 years from the borrower's last date of attendance, but it's unlimited if it's related to an adverse action by ED. Remember, one of the new claim standards is whether there's a prior sanction or adverse action by the department. All right. So let me just offer a couple of 40,000-foot level thoughts, and then I'm going to turn it over to Jeff, and we're going to start going by section by section. And this is in the memo, right? So I spoke before about this notion. It's an important distinction to keep in mind that there's this initial adjudication process where a borrower files a claim, and the department, a staffer at the department is deciding whether or not they think that the institution engaged in the act or omission. And this is the initial adjudication process where this is decided. And if they think that the school did, then there would be a presumption that the borrower was harmed to the full amount of the loan, and the department could discharge the loan. Right. There is a secondary process, though not detailed in this proposal, but there still would be some type of secondary process pursuant to which the department would seek to recover or could seek to recover the discharged amounts from the institution. So the argument from at the negotiating table and from some people at the department has been, well, that initial process, the adjudication process, institutions really their involvement should be limited, because this doesn't determine whether or not they have to pay back any discharged amounts. Of course, if you're an institution, I think most institutions and lawyers would look at that and say, well, that doesn't make any sense. I mean, you're deciding whether the institution did something wrong and whether there was misconduct on the part of the institution. I mean, the claim is essentially the borrower is saying that the school wronged me. Clearly, the institution should be involved in that process, right? Okay, it's critical. It's critical that this initial claim adjudication process, in our view, includes equitable standards and due process protections for both borrowers and institutions. But I want to be really clear here, and I think this is an important point to emphasize. It's not just because these parties are entitled to fair process. And I've heard in the past folks, when they start talking about why institutions should have a seat at the table during the initial adjudication process, sometimes that conversation immediately or very quickly goes to sort of this notion of entitlement. Well, we should get a seat at the table because it involves us, somebody has alleged we did something wrong, and we have due process rights under the Constitution or under some other law or rule, and that's why we should have a seat at the table. But in my mind, that is not the biggest reason. The most compelling reason institutions should have a seat at the table is because it reduces the likelihood of erroneous discharges. I mean, the whole point of this process is to fairly and accurately adjudicate claims between borrowers and institutions. The borrower has alleged that the school did something wrong, and the department's job is to try to decide whether that is true or not. And if the department doesn't involve the institution and get the best evidence available, it reduces the likelihood of a just outcome. So I encourage you, when you're thinking about comments, before you go to, because the Constitution entitles us to due process, which is important and a valid argument, I think the most important thing to remind the department is, look, we need a fair and equitable process, because if we don't have a fair and equitable process, you're going to increase the likelihood that you don't get all the relevant information and facts, and that you're going to reach an inaccurate result and grant an erroneous discharge. And the next piece of this point, which is critically important as well, is that erroneous discharges harm students, they harm taxpayers, they clearly harm schools, and potentially even borrowers, right? Because if schools are paying out for erroneous discharges, who's going to pick up the tab for that? I mean, you're going to have to pass those costs through, right? Whether that's to put new compliance frameworks into place, whether that's to, litigate or defend yourself, and someone's going to have to assume those costs, and it's probably future students, right? It's clearly bad for taxpayers if you've got erroneous discharges and then the department and subsequent proceedings can't recover against schools, because in the subsequent proceeding an administrative law judge or someone says, well, no, I mean, the evidence clearly demonstrates that the school didn't do something wrong. All right, but the taxpayer, you've still discharged those loans, so the taxpayer's on the hook, right? And it could even be bad for borrowers. If you're discharging a loan, think about this. If you've got a really low standard at the department and it's too easy to discharge loans, right? You don't have a fair process, you're not getting all the relevant evidence, you discharge those loans. Then that means that, and then the school is required to pay that back. Let's say they do, they pay it back. Now the borrower owes that school money, because remember, I mean, the borrower used the loan to settle up on their ledger. And so if the loan is pulled out, then ostensibly the borrower owes that money. And if schools theoretically were to go to court and a court of competent jurisdiction looked at all the relevant facts and said, no, I mean, the school didn't engage in any act or omission or any wrongdoing, so the borrower still owes that money. It's bad for everybody, right? It's bad for everybody if you don't have a fair and equitable process that promotes good and just and accurate outcomes. And I encourage you, when you're thinking about comments and how to frame everything in the context of this rule, it's important, I think, not to make it about, we should get rights because we're owed rights, but really about, you need to include schools and you need to give them fair and equitable processes so that you can get all the right information so that you can make the right decisions, right? Okay. With that having been said, and all this is in the memo, the TC comments memo. Let's get to the section by section analysis. And with that, Jeff, I will toss it to you, sir.
All right. Thank you, and good afternoon, everybody. Our first point in our section by section analysis, we're going to talk about the expanded grounds for a BDR claim in the proposed rule. Not that that's necessarily unusual, but what is unusual is that the department is proposing to apply those expanded grounds retroactively, regardless of when a federal student loan was made. So these new and expanded grounds for a BDR claim could apply back as much as 20, 25, 30 years. And we know that these claims can date back that far. Having represented some schools in responding to BDR claims that were filed with the department, some of them have been filed by borrowers who didn't attend the school for 20, 25 years. So the new rule is proposing expanded grounds that a borrower can use to make their BDR claim. It's unusual, and you didn't see this in the 2016 or the 2019 rules, which they only applied it going forward, their grounds for BDR claim. The 2016 rule said, okay, it's a loans made on or after July 1 of 2017. The 2019 rule said our grounds are going to apply to loans made after July of 2020. With the new rule here that's being proposed, the department is proposing to do these and make these expanded grounds and apply them retroactively. Law is relatively, and actually I'd say fairly clear, that they cannot do so. There's a Supreme Court case dating back to 1988 saying that an agency does not have the power to promulgate, to issue a retroactive rule unless Congress has expressly authorized the agency to do so. And that's clearly not the case here. If we look at the Higher Education Act, the sections that even allow for the borrower defense process, there's nothing in that statute that talks about retroactive rulemaking by the department. So that retroactive application of these expanded grounds, in all likelihood, is unlawful. And the department has acknowledged that and said that in the commentary to its proposed rule. They said, we know we can't apply this retroactive. It would be unfair. It's impermissible. And we can't hold institutions liable based on expanded grounds that weren't in existence at the time that it helped make the federal loans and financed its students' education at those schools. The department has suggested in commentary, well, we'll take care of that problem. We promise you, the schools, we're not coming after you. If something happens because of one of the expanded grounds for a BDR claim, we're not going to hold you liable. Problem with all of this is that it's nowhere in the regulation, nowhere whatsoever. You're relying on a hollow promise by the department saying we're not going to apply this retroactively against the institution. We're going to apply it retroactively for the benefit of the student, maybe give them a discharge on an expanded ground that didn't exist at the time they took out their loan. But there's nothing to hold them to their promise to the school that education department won't come after the school and try to apply one of its expanded grounds against the school. That clearly violates the Supreme Court precedent. The department's recognized it's unlawful, but where in the regulatory text is that? It's not there. And so we think at the very least the department should come forward and be straightforward in the regulation that they're not going to apply the expanded grounds for a BDR claim against a school. And we have here for you a suggested comment on this topic in which we say, and you can paraphrase this or you cut and paste it directly, because retroactive application is prohibited by well-established judicial precedent and public policy, the department must specify in the regulation, not just in the commentary to the rules, but in the regulation itself, that institutions will not be subject to recoupment actions or otherwise deemed to have engaged in misconduct for acts or omissions that do not violate current law. So we have the retroactive problem, and that's because we have expanded grounds for a BDR claim that are being applied to loans well in the past. Now I'll turn it over to Aaron. Aaron's going to start talking about what are these expanded grounds for a BDR claim that are in the proposed rule.
Many thanks, sir. Many thanks. So I mentioned earlier, if you look in the law, it only divides these up into 5. Favorable judgment and prior ED sanctions have been grouped together for some reason. But there really are 6 grounds now in this proposal: substantial misrepresentation, substantial omission of fact, breach of contract, aggressive and deceptive recruitment tactics, favorable judgment, prior ED sanctions. The ones in red are brand new. We've never seen in a prior rule. I'm going to start with substantial misrepresentation. So the department's, and this is important to understand, that the department's current long-standing misrepresentation regulation, which is at 66871, it's there right now. It defines a misrepresentation to include representations made by an institution or most of its vendors, if the vendors are doing anything related to educational programs, recruiting, marketing, that have the likelihood or tendency to mislead under the circumstances. So there's no intent requirement. That may surprise you, but just to repeat that, right now in the law, the department has a definition of misrepresentation that includes almost any representation made by a school or one of its vendors to virtually any member of the public. And it doesn't require any intent to deceive or misrepresent on the part of the party making the representation. All it requires fundamentally is that the representation had the likelihood or tendency to mislead under the circumstances. So it's an extremely low bar. But, and this is important, the way the law has always been designed, going back decades, is there's a second definition, and that definition is a substantial misrepresentation. And the department's only actually authorized to take action against a school if the school makes a substantial misrepresentation. So to say that again, under current law, if the department could actually find that you engaged in a misrepresentation, and that's not a basis for action, it would have to find that you engaged in a substantial misrepresentation. And that definition essentially is a misrepresentation that was made and could reasonably be expected, where a person could reasonably be expected to rely or has reasonably relied to that person's detriment, right? So in other words, and this is a pretty reasonable standard, what the department is saying is we've got this idea of misrepresentation, but before we take action, we would have to reach a determination that that misrepresentation, someone could have reasonably been expected to rely on it. They don't have to actually have relied upon it, but they could have reasonably been expected to rely upon it to their detriment, right? And that's a substantial misrepresentation. So you'll recall the Obama administration took this definition of substantial misrepresentation and they made that a grounds for a bar defense claim. Okay, but unlike our current proposal, the 2016 rule from the Obama administration also expressly requires that, at least in the context of individual borrower claims, the borrower must have actually reasonably relied upon the misrepresentation to their detriment. Okay, so if under the Obama era rule, an individual borrower filed a claim, then there was still the requirement that the borrower, for it to be a bar defense claim, the borrower would have to show that they actually relied on whatever that act or omission was. So it would be a substantial misrepresentation under that current definition, but sort of layered on top of that was this actual reasonable reliance requirement. Now, you'll recall under 2016, if you had a group claim that was prosecuted by the department, then there was an assumption that all the borrowers in the group had actually relied, so you didn't have to demonstrate it. But also recall that those group claims went in front of an administrative law judge. Okay. So the current proposed language, in contrast, only requires the department to conclude that a substantial misrepresentation occurred. All right, that's it. So you take that definition that's in 668.71, and if that substantial misrepresentation took place and it occurred in the context of the student's decision to attend or educational program, right, then it would be a basis for the borrower to bring a bar defense. So what that means is, practically, there's one, no requirement that the institution intended to mislead or deceive. Because remember, that intent concept is not present in the current definition of misrepresentation or substantial misrepresentation that exists at 668.71. There's also no requirement that the borrower actually and reasonably relied on the alleged misrepresentation, or that the borrower actually experienced any harm, much less material harm. So just to say that again, a borrower, if an institution could make a mistake, they could essentially make a representation without intent, right, that had a tendency to mislead. And if the department determines that that borrower could have reasonably relied on it, then it could be sufficient to be a bar defense claim and get their loans discharged, despite the fact that the borrower did not actually rely on it or suffer any harm. Because remember, there's that presumption that the borrower did suffer harm to the full amount of their loan. Okay. Here's our suggested comment. We think the substantial misrepresentation standard proposed, 685.41b1, should be revised to require the department to make a determination that the borrower reasonably actually relied. And remember, if you can include this if you wanted to, the Obama administration, at least in the context of individual borrower claims, did require that. So this is not, you don't have to go out on a limb, this isn't something that was exclusive to the Trump administration. The Obama administration bought into this idea that at least in the context of an individual claim, someone should have to demonstrate that they actually relied on the act or omission, right? We also believe that the department should have to make some sort of determination of material harm to the borrower, right? This notion that the department would assume that borrowers were harmed to the full amount right, we think is inappropriate. We don't think it's appropriate that, one, a borrower would not have to actually even rely on the act or omission, and two, there would be an assumption that they were harmed to the full amount of their loan. We think institutions should strongly support the use of substantial misrepresentation in the standard instead of misrepresentation. What do I mean by that? So one other note, it's important when you do comments not only to talk about what you don't like, but to sometimes talk about what you do like. In the draft language that the department was throwing around during negotiated rulemaking, they actually suggested that they would tie this not to substantial misrepresentation, but just to the definition of misrepresentation, right? I just went through this, right? I mean, the definition of misrepresentation doesn't even require that someone could have reasonably relied on it, much less that they actually did or were harmed, right? So we think that the fact that the department, and that was also inconsistent with the way current law is constructed. So one thing you might say is, in addition to the first half of this comment, saying, look, we don't like this stuff and we think there should be a finding of actual reliance and material harm, we also think you might want to comment and tell the department, by the way, we really support the idea that you are using substantial misrepresentation as the trigger and not the even lower standard of simple misrepresentation, which was suggested in the draft circulated during NEGREG. Hope, over to you.
Good afternoon, everyone. I'm going to discuss the second standard, substantial omission, found at proposed 685-401B2. The department's suggested definition of omission of fact is at 668.75, and under that definition, the department would require that the omission of fact relate to, quote, material information, unquote, and that, quote, a reasonable person would have considered the omitted information in making a decision to enroll or continue attendance, unquote. However, interestingly, there's no requirement that the omission be intentional on the part of the institution or that the borrower actually relied on the omission or suffered any material harm. You can see that this closely echoes the substantial misrepresentation structure. So here again, as we saw with substantial misrepresentation, there is this rebuttable presumption at proposed 685-408A, and under that provision, the department would be required to assume that the borrower was harmed by the alleged omission of fact in an amount equal to his or her entire loan. So based on this standard, we recommend you considering commenting to the effect of requiring the department to make a determination of reasonable actual reliance and material harm to the borrower. And again, that we would eliminate this rebuttable presumption proposed at 685-408A. Next, we have Aaron, who's going to discuss breach of contract.
Thank you, ma'am. And you know, when you're couching, by the way, I mean, when you're making these comments, I think it would be fair to say, look, we're not, however you want to say this, we're not suggesting that, or you know, maybe the way to put it is, if a borrower has been harmed by an institution, and the evidence shows that, you know, the objection is not to the notion that the borrower should be made whole, or that the loan should be discharged, you know, in an amount equal to the harm that they incurred. The objection is to the notion that the department would not even evaluate or determine whether or not the borrower actually relied on the act or omission or was harmed. So I think, you know, one thing to think about when you're phrasing these comments, if you decide to make comments, which again we hope you will, is you know, you can phrase them in a constructive way, right? And to make sure we're not just saying we don't like this or we don't like that, but we're saying, look, it's okay to, we don't have a problem if somebody's been harmed that the loan be discharged in that amount, right? And that the department, but the department needs to make some determination as to whether or not they even relied on these acts or omissions or they were in fact harmed. And this comes up again here in the breach of contract standard, which is a tricky bit for several reasons. So the proposed rule would permit borrowers to bring a claim, and again, this is a revival of something we saw from the Obama administration in 2016, if the institution failed to perform its obligations under the terms of a contract with the student. Now, that's a pretty vague concept, a contract with the student. and such failure was in connection with the borrower's decision to attend or to continue attending, or their decision to take out a federal loan. That would still probably cover a lot of contracts, right? Because most things between a school and a student ostensibly relate somehow to their decision to attend or to continue attending. First of all, there's no requirement that the breach be material. So a borrower can file a claim even if it is a non-material breach, and on its face, even if they specify it's a non-material breach, it doesn't matter, because the standard itself doesn't require that the breach is material, right? So that would permit borrowers to assert a defense in the vast majority of instances where a breach has resulted in injury. Rather, stating this in the positive, we think if there was a materiality requirement, it would still permit borrowers to assert a defense in the vast majority of instances where there was a breach that actually resulted in injury to the borrower while deterring frivolous claims, right? So we think a materiality standard would be good, and you'll see that in our comment. Second, under the current proposal, the rebuttable presumption of proposed 685, which you've heard a lot about from us already, we're going to keep beating that drum, which would require the department to assume that the borrower was harmed, right? It's at tension with the approach that typically is taken to resolve, determine harm and determine relief in breach of contract matters. So under common law, typically it's the case that a court would try to determine the extent to which the party bringing the breach claim was harmed by the breach. And then the idea is the court tries to determine an amount of relief that makes the party whole, right? And that's absent any consideration for punitive damages, which is also not on the table in borrower defense claim processes, right? We're strictly talking about the most relief can be, so that you know, is the full amount of all the loans. There's no such thing as punitive damages in a borrower defense proceeding, right? But again, typically in breach claims, a tribunal would determine what's required to make the injured party whole, and that's not the case here. And instead, without regard to how much the borrower might have actually been harmed, the department's just assuming that the harm, whatever it was, again, is equal to the full amount of all their loans that they took out. By the way, I want to specify, we're not talking about the loans they took out in the term when the act or omission occurred. We're talking about all their loans, right? The department also does not specify what it believes would constitute a contract, and we think that's potentially problematic. Now, you as institutions may not want them to specify that. Notably, in the preamble to the 2016 rule, the Obama administration observed that a contract could include an enrollment agreement and any school catalogs, bulletins, circulars, student handbooks, or school regulations, which is frightening because that's a lot of the paper that you guys publish and put out on the airwaves. It used to be, I think, for a very long time, particularly in traditional higher ed, and this is still the case, that there is no sort of enrollment contract. I think the thinking was that courts were very deferential to schools, and schools should sort of say what the contract was or was not. That thinking, at least in some respect, is changing in some jurisdictions. And candidly, it may be time that traditional higher ed wants to think about instituting something along the lines of enrollment contracts so they can specify what is actually the agreement between the parties and what's not. At any rate, here's our suggested comment. We think the breach of contract standard, first of all, should require that the department make a determination of materiality. In other words, was the breach even material to the education or the sort of contractual relationship between the parties, or did the institution still deliver all of the education and the vast majority of what was promised under the contract, right? Did the breach harm the borrower in some way? There shouldn't just be an assumption that if there was a breach, without regard to materiality, it harmed the borrower to the full amount of their loans. I mean, there should be some determination consistent with the approach that every other court takes when you talk about breach of contract cases. There should be some examination of, what was the nature of the breach and to what extent did the breach actually harm the borrower. And then that should be the amount, if any, that they receive relief. Also, we suggest here, but you can think about whether you agree with this or not, we think the department should specify in the regulation the documents that would constitute a contract between school and student. But ideally, they would have done that in the proposed rule so that you would have an opportunity to comment on it. And here, in the absence of anything along those lines, what you might want to say is the department should specify it, and this is what it should be, and say, an enrollment contract if there is one and nothing else, or it should be what the parties agreed to, right? So have the parties agreed that, this contract is the full contract between the parties and nothing else? And, if that's the case, maybe the department should honor that, right? The agreement between the parties is specified. But certainly a lot of opportunity for improvement here on the part as far as institutions are concerned. All right, that brings us to our second secret word as we round out our first hour. The second secret word is sanction. I didn't pick the secret words, but I like how all of these seem to roll from our conversation a little bit. So please click the radio button next to the word sanction. And then as soon as you do that, we'll give you about 10 more seconds. I'm going to kick it over to Hope once again to talk about a new standard that the department has put into place, which is aggressive and deceptive recruitment. And, we're talking about the bar defense standard here. We're not talking about at length the department's new definition. So if you are interested, you could also review the new definition that they have introduced of aggressive and deceptive recruitment and sort of think about that at length and whether or not you want to comment on it. But again, what we're really talking about here is how that new concept or definition works as a new standard or basis for asserting a bar defense claim. And with that, Hope, I will kick it to you.
Yeah, so as Aaron said, proposed 685-401B4, we get this standard for aggressive and deceptive recruitment. And the underlying definition for this is at proposed 668-500. And that definition would include conduct by the institution or one of its representatives or any ineligible institution, organization, or person with whom the eligible institution has an agreement to provide educational programs, marketing, advertising, lead generation, recruiting, or admission services. And the department provides a list of examples to walk through the conduct that may be included in this definition. And those examples include pressuring students or prospective students to make enrollment decisions immediately, taking advantage of their lack of knowledge regarding higher education, or failing to respond to their requests for information. And there's no indication in the rule that this is an exhaustive list, but these are the examples the department has provided to illustrate this aggressive, deceptive concept. So the proposed rule would permit borrowers to bring a claim if the institution engaged in aggressive and deceptive recruitment conduct or tactics in connection with the borrower's decision to attend or to continue attending, or the borrower's decision to take out a federal loan. Under this new proposed standard, it would not require that the school intended to act aggressively or deceive, nor would it require the department to make any determination that the tactics in question impacted the borrower's experience, decisions, or education, or otherwise caused any material harm to the borrower. And of course, we're seeing again this theme about the intent of the school not being relevant to the determination. And again, the rebuttable presumption at 685-408A would require that the department assume that the borrower was harmed by the alleged tactics in an amount equal to his or her entire loan. Next, based on this standard, we again have a suggested comment, and in keeping with our other suggested comments, we think that the department should be required to make a determination of reasonable actual reliance and material harm to the borrower. And we also think that the rebuttable presumption proposed at 685-408A should be eliminated. Jeff is going to walk through the next standard, favorable judgment.
Yeah, so another ground we have here in the proposed rule for a borrower to get his or her loans discharged is if they can obtain a favorable judgment. This is under 685-401B5-1. And it says, the rule says, if borrower get a favorable judgment, presumably against their former school, quote, in connection with the borrower's decision to attend or to continue attending, or the borrower's decision to take out a federal loan. We believe this standard is vague and needs to be reworked for several reasons. First of all, the focus should be on what was the basis, what was the ground for the judgment, because the ground for the judgment should be a ground for a BDR claim, not some ground that's not a ground for a BDR claim but resulted in a judgment. Let me give you a hypothetical example. Let's say students on campus, they slip and fall, or let's say they're assaulted on campus. They could come in and say, you know what, I assumed that my campus was safe, and that's the reason I attended there. I got a judgment. I want my loan discharged. Now, the underlying assault or the slip and fall would not in itself be a ground to get the student loan discharged. But if I go beyond that and I transform that into a judgment against the school, who knows? Under this rule, is that a basis to get me out of my loans? The judgment standard in the proposed rule doesn't say so. And the problem a lot of times, too, and this spills over, is that when you're in court and you get a judgment, a lot of times you don't know what a jury, if you have a jury trial, or the judge, if you have a judge-tried case, what they've decided. A lot of times you'll just get a very perfunctory decision. We, the jury, find in favor of the plaintiff, the borrower, or the court might do something similar. So you really don't know what's been decided, what's been adjudicated. You don't know if a valid basis, a valid ground for a BDR claim was actually adjudicated by the jury or by the judge. Because of that,
Jeff,
that makes the standard too vague. Yes.
Yeah, and you could, I mean, I assume too, they could, in a complaint, they could allege a lot of different things, right? And some things might be the basis for a bar defense claim if a court or jury said yes, and other things might not be. And that judgment you get might not specify what they actually got to and made a decision on. Is that right as well? I mean, it sounds like it's sort of similar.
Yeah, that's a possibility. I mean, you could have multiple claims, and you might have a judgment that says, okay, I breached a contract against my school, and maybe I also had a slip and fall, and maybe the judgment will split and tell you what the jury or the court decided, but you may not. And so you may end up getting a judgment where it's unclear what the basis of the judgment was. And so that needs to be cleared up. So what we put in here is for a proposal in language that you could use for a comment is that the favorable judgment standard should require that the judgment include a determination that the institution engaged in conduct, that means grounds, that would otherwise constitute a borrower defense claim. And we also suggest arguing that judgment should include a finding of reasonable, actual reliance and material harm to the borrower. And with that, I will turn it back over to Aaron, who will talk about the prior ED sanction ground for a BDR claim.
Thank you, sir. So, our hope is that you'll consider commenting on any or all of these. But I have to say, certainly of the new things that are proposed, and of all the 6 that are out there right now, this is the one that troubles me most. So under the proposed standard, this is again at 685-401B5. It's in Roman numeral 2. It would permit and this is new. We've never seen this. We didn't see this under the Obama administration, certainly not under the Trump administration. It would permit the department to certify a claim and discharge a loan if the department determines simply that the secretary sanctioned or otherwise took adverse action against the institution at which the borrower enrolled. Let me say that again, because it's so sort of simplistic in a way it's hard to even wrap the brain around. I mean, the department could initiate a group. I mean, in theory, an individual borrower could also bring a claim, but a department could initiate a group, and it would state a valid bar defense simply based on the fact that the department had previously sanctioned or otherwise took an adverse action against the institution at which the borrower enrolled. So we think this standard is problematic in the extreme. First of all, there's no meaningful definition of sanction or adverse action. There's a spot a little later in the proposed rule where the department gives examples of final actions, and it's interesting because they use the phrase final action there, but they reference back to this standard. So presumably those are some examples, but it's illustrative at best, not exhaustive, right? But get this, there's no requirement that that sanction or adverse action was material to the institution or the borrower, or that the conduct that gave rise to the sanction or misconduct was reasonably relied upon by the borrower, or harmed the borrower in any way, much less to his or her material detriment. So what are you talking about? I mean, you could be talking about a program review that the department previously did at your institution. Everybody gets program reviews, everybody, right? And let's say as part of the program review, the department made a determination that there was some consumer information that you weren't properly disclosing. Now, you all know, if you're in the business of higher education, that there are literally scores and scores and scores of consumer information obligations now, and they're just continue to get piled on. right? There are all kinds of things that you have to hand to students and make available to students, et cetera. And consumer information failures are one of the top 10 program review and audit findings every year these days that are cited by the department. So let's say they did a program review and say, oh, you didn't hand out all your annual security reports, or you didn't do, something else correctly, right? Again, there's no requirement here that sanction or adverse action, and that could be a sanction or adverse action. You got a finding in a program review that you didn't satisfy these consumer information requirements. It doesn't have to be material to the school, so it's not necessary that whatever you did wrong somehow impacted your operations or your financial ability or even your administrative capability, or to the borrower. There doesn't have to be a nexus there. The borrower doesn't have to demonstrate. It's not like the others, right, where it said in a connection with some decision about their attendance or continuing attendance. There's no requirement in the standard, right? In fact, there's no requirement that the conduct that gave rise to the sanction or adverse action even really be related to the borrower, so long as it relates to the making of a direct loan for enrollment at the school or the provision of educational services. And I think this concept, the provision of educational services, is so broad that the department, if it wanted to, with regard to almost any consumer information requirement, if you got dinged in a program review and the obligation was that you provide some sort of information to borrowers, right, that would presumably relate in some way to, your educational experience or programs or services, right, that the department could say, well, that's a prior adverse action. I think this is and the other thing I want to remind you of is that there's no obligation under this rule if the department initiates a group claim. First of all, there don't have to be any underlying individual claims, right? So there's no requirement that any borrower ever complained about the lack of getting consumer information. And now this doesn't go in front of an ALJ. The department is suggesting this would just be decided at the staff level. So what the department could do is they say, in that program review, we realized that all your crime statistics were wrong and that you didn't hand out your annual security report for this year. So every borrower who should have received that annual security report, we're going to initiate a group claim, and we're going to put them all inside that group claim, right? Doesn't matter that nobody's filed a complaint. We're going to assume that they were all harmed, and there's no requirement that anybody actually relied on this thing, right? As with all borrower defenses, again, that rebuttable presumption is at work under this proposed rule. And get this, under proposed 685-404B, I'm skipping a little out of turn here to process, but institutions have no opportunity to respond to claims under this standard. So all the process stuff we're going to talk about that exists if a borrower brings a claim under one of the other standards. Here, I'm sure philosophically the department's view is, well, the program review has already determined that you didn't hand out the annual security report. So you don't even get a seat at the table if we bring a group claim. We did the program review. We dinged you for not having an annual security report. We're certifying the claim. It's going to be managed at the staff level, not by an ALG. It doesn't matter that no one actually relied upon it. We're going to assume everybody was harmed to the full amount of discharge loan. You're not involved in the process. Here's the check. This is terrifying to me. And if you're going to comment on any of these standards, I hope that you will take some time to wrap your brain around this one and consider the implications for all institutions of higher education and comment on it. Also, just the last note, under 685-49C3 proposed by the department, adjudications made under this section, the department can initiate a recovery proceeding to collect at any time. So there's no time limit. Here's our suggested comment. The proposed standard here should be significantly revised to require, among other things, that the borrower reasonably actually relied to his or her material harm, you've heard that before, upon the act or omission that was the subject of the prior ED sanction. So there should be a nexus between the actual borrower whose loans are being discharged and the act or omission in question. Further, we should revise this new rule to eliminate the provision denying institutions an opportunity to respond to claims brought on this standard, because even if you got dinged in a program review, you ought to still be able to show at least around the harm question, right? Because in even where the rebuttable presumption exists under the other claims, you have some opportunity in theory to provide evidence, a preponderance of the evidence demonstrating that the borrower is not harmed, and to try to get the department to make a decision that that rebuttable presumption should be overturned. But if you have no opportunity to participate in the process, that means you don't even have an opportunity to show that all of your borrowers and students weren't harmed by the fact that you didn't distribute your annual security report that year. And finally, they should revise the proposed rule to provide a reasonable statute of limitation for recovery actions relating to claims made under this standard. All right, statute of limitations for claims. Jeff, I'm back to you, sir.
Okay. So under 685-401, there will not be a statute of limitations for claims. So that means that a borrower who was a student as long as 20, 30 years ago could come forward and say, hey, my institution breached its contract with me, or they misrepresented stuff to me. I want my loans discharged, and I want to be repaid what I've already paid on my loans. We've already experienced this to some extent in some BDR claims we've defended where students were making those kind of allegations from decades ago. The proposed rule would allow that to continue, where there is no limit, no time limit for a student to be able to assert a BDR claim. Now, you might ask, well, what's the problem with that? Well, it's the problem that drives a statute of limitations for all kinds of claims when you file them in court. Every claim out there, no matter if it's a breach of contract, if it's a slip and fall, product liability claim, there is a statute of limitations that each state has, and they vary from state to state in terms of how many years you have to file a lawsuit over it. And we've always had statute of limitations. They date back hundreds of years, and the reason being is because, hey, you got to get going. You got to file your claim. The reason being is that it's prejudicial if you wait too long, because your adversary, your defendant in the case, they have a right to defend themselves. And if you wait too long, people's memories are going to fade, documents are going to disappear, the evidence needed to defend the claim will no longer be there. And that's especially so with schools in their record keeping. We just don't keep records forever on every student, every record we have on a particular student. The Department of Education has encouraged, and other state agencies have encouraged us to limit, to some extent, how much we keep in records for students, because we're trying to protect student privacy. And then from a school perspective, too, the costs are astronomical. And trying to keep and maintain records for students who have left your institution 10, 15, 20 years ago. Without a statute of limitations, though, you're put at a severe disadvantage if a borrower comes in many years down the road and says you did something wrong, you breached your contract, you lied to me. You have a hard time defending that. And that's why there should be a statute of limitations in the rule as to when a borrower can bring a BDR claim. And it should not be this, hey, come whenever you want, raise your claim whenever you want. There should be a time limit on that. And so we've suggested as a comment that you encourage the department, let's give a reasonable statute of limitations to BDR claims. That way we don't have this unlimited liability that can go on forever and at prejudice to our schools who no longer have the witnesses, may no longer have documents, and a way to respond to claims made by borrowers many, many years down the road. With that, I will turn it back over to Aaron, who is going to talk about the group claim process.
Thank you, sir. And I'll just remind folks, too, if you remember those slides at the beginning, under the 94 rule, borrowers could bring a claim any time, but the department had a very short time frame to bring recovery actions. And then under both the 2016 rule and the 2019 rule, there was a statute of limitations on when borrowers could bring claims. So this is not an out-of-left-field request, right? I mean, the Obama administration acknowledged it. The Trump administration acknowledged it. And as Jeff indicated, it's just really unusual and bad public policy to have no limitation whatsoever. Group claims we mentioned earlier, we've talked a little bit about Section 455 of the HEA, which is the statute, directing the department to go out and establish the acts or omissions of an institution of higher ed that a borrower can assert. The statute doesn't contemplate a bar defense claim outside of a collection proceeding for starters, although I think the ship has sort of sailed on that argument. Even the Trump administration conceded that, we weren't going to force borrowers to wait until they were in default on loans and in the context of a proceeding. But the statute certainly doesn't authorize a department to certify a group of borrowers and initiate a proceeding without any claim filed, right? I mean, look at the language of the statute. Specifying regulations which acts or omissions of an institution of higher ed a borrower can assert as a defense to repayment, right? And here the department is creating this concept that allows them to certify a class of borrowers without a claim ever having been filed, or any showing that a borrower relied upon or was harmed by some act or omission of the institution. I mean, we think this is a pretty clear overreach as far as statutory authorization goes, even when you consider that agencies have a fair amount of discretion. What's also remarkable and new here that we didn't see even in 2016 is the proposed rule would permit a state party requester, which includes states, state attorneys general, and state oversight or regulatory agencies, to initiate a group process by submitting a request that the secretary form a group. So, not only is the department ostensibly exceeding its statutory authority by granting itself the ability to initiate group proceedings, it's actually granting some level of rights to state party requesters by giving them the ability to request the initiation of a group process. We think this is all way outside the bounds. I know this is a little bit more of a legal argument than some of the others, but we certainly think it's an important one and one worth making. Our suggested comment: because Congress has not authorized the department to certify a group of borrowers or to initiate a group proceeding without any claim filed or collection action underway, the proposed group process eliminates our group claim concept. Elements of the proposal should be removed. Finally, with that having been said, I'm going to kick it to Hope, who's going to talk to you about the proposed process that would be allowed, to the extent institutions have the ability to participate here at all, what that looks like, and the extent to which it is deficient. Hope, with that, I know there's a lot to cover here, so take it away.
Yes, thank you, Aaron. So as we discussed at the top of the presentation and have continued to emphasize throughout, it is absolutely critical that the initial claim adjudication process includes equitable standards and due process protections for both borrowers and institutions. And that's important not only because these parties are entitled to a fair process, but also because it reduces the likelihood of erroneous discharges. So as we've been discussing, the whole point of this process is to adjudicate claims fairly and accurately such that the department can reach just outcomes. And in theory, that's what due process is for. And in other areas, the department seems to have acknowledged that. So for example, in 1995, in the 1995 Notice of Interpretation, the department observed that schools are, quote, entitled to due process in these proceedings. And in the preamble to the proposed 2016 rule under the Obama administration, the department acknowledged that a stated goal of the rule was to provide due process for students and institutions. However, this administration, less enthusiastically, offers that the department would, quote, provide the institution with due process as appropriate. And we feel that the due process proposals, or lack thereof, in this rule reflect this less enthusiastic attitude pretty clearly. As detailed in the following slides, the procedural deficiencies in the proposed rule are manifold. And just as Aaron mentioned, this is a long section, but the length of the section is indicative of the significance of these deficiencies. So with that, I'll start to walk through the individual and group process, and the department outlines this in 685-402 through 406. So to begin, neither of the two processes guarantee that the department staff overseeing the adjudication of the group claim will be qualified to do so, meaning there's no guarantee that an administrative law judge will be assigned to adjudicate the claim rather than a department staff member. And further, neither process guarantees that the department staff overseeing the adjudication of the claim will be free of any conflict of interest as regards the borrower, the specific school, or the type of school that is the subject of the claim. Further, neither process requires borrowers filing claims or other parties providing evidence to certify under penalty of perjury that the information submitted is true and correct. So the requirement to certify under penalty of perjury is a critical deterrent to frivolous claims, but remarkably, in contrast, institutions are required to make such a certification under proposed Rule 685-405C. This is a very poignant example of a scenario where institutions would be held to a different standard than borrowers are. While proposed 685-405A provides that the department will notify the institution of a claim, it does not guarantee a process or timeline for providing such notice to institutions. So that means that the department could notify the institution weeks or even months after the formation of the group, after the claims were received, if any were received at all, or after borrowers were notified. Next, the proposed processes do not require the department to provide a written copy of any claims or to identify or provide to the institution the documentation obtained by the department or otherwise supplied by a borrower in support of a claim, or to identify or supply the records that the department official considers relevant to the claim. So this is describing a process in which the institution may never see the documentation, the evidence, or the claim itself upon which the borrower has based the claim. The proposed processes also do not guarantee the school a specified time frame for providing a response to additional information requests from the department. So we see under proposed 685-405D that the institution must respond to the department's officials' information requests within 90 days of receipt, but there's nothing in that provision that guarantees that institution a 90-day window to respond. So the way that could potentially play out is that the department could impose an abbreviated institutional response time while simultaneously retaining the benefit of enforcing the 90-day deadline at its discretion. So the department has a lot of control and the institution would just be at the mercy of that. Moving on, under proposed Rule 685-406F6, the Secretary would plan to provide an interim update to individual borrowers or those state requesters that we discussed earlier in the presentation who have requested a group process, and the Secretary would provide that interim update no later than 1 year after providing initial notice of adjudication. And the interim update would indicate to those parties the Secretary's process in adjudicating the claims and would provide an expected timeline for rendering a decision. And given the backlog of these claims, we can understand why this interim update is valuable to the parties involved. But unfortunately, the proposed rule does not contemplate that update for institutions. Further, the proposed processes do not provide any right to a hearing in either the adjudication phase or the recovery phase. And it is, as we discussed later in the presentation, it's unclear what procedures, if any, would govern the recovery phase under the proposed rule. Next, the proposed processes do not provide an institution any right to pose questions to the adjudicator, a borrower, witnesses, or any corroborators regarding disputed factual issues. And thanks for hanging in there. This is our last slide on the process. So the proposed processes do not guarantee the school will receive a copy of the official's written decision, much less that it will receive it at the same time as the borrower. So under proposed Rule 685-406E3, the department would provide copies of the written decision to the members whose claims were adjudicated, and if applicable, meaning if state requesters who requested the group claims were involved, they would also receive copies of the written decision. But the rule clearly states they would only provide copies of the written decision to the school, quote, to the extent practicable, unquote, leaving open this possibility that the department has given itself permission not to provide the copies at all. Next, with regard to any group process based on prior department actions, as we discussed, that's contemplated under 685-404, the institution would have no right whatsoever to participate in the adjudication process. And as we will discuss in much greater detail in the coming slides, finally, the proposed group process does not provide any opportunity for the institution to request reconsideration under any circumstances if the department official approves the claims in full or in part. But again, remarkably, the Secretary, state requesters, and borrowers all have the opportunity to request reconsideration in a range of circumstances. So the only party that would be left out of the opportunity to request reconsideration would be the institution. So our suggested comment would be that we encourage institutions to comment on any or all of the deficiencies that we have highlighted in the prior slide, given this overarching thought that the proposed individual and group processes should be significantly revised to afford institutions basic due process and fairness protections in furtherance of this notion of wanting to reach just outcomes. With that, we will move on to our third secret word of the session. Our third secret word is judgment. Please select the correct word from the list below. Again, that word is judgment. We'll give you just a few more seconds to make sure you bubble in that correct word.
Yeah. And I'll say while you're doing that, I'll just butt in here because I know Jeff is going to talk about reconsideration next, actually. But, you know, I just want to say I really appreciate, we know this is a late Friday afternoon slot, and that particularly the folks on the East Coast are hanging there, you know, 4:30 on a Friday talking about a proposed rule that's probably not making you feel warm and fuzzy inside. We also appreciate that we're throwing a lot at you. Just a couple of thoughts while we're waiting. I mean, the first is take a deep breath. One of the reasons we gave you the memo and the slides and the webinar and recording is you don't have to remember it all right now. You know, you can let it sort of wash over you, digest what you can, and come back to it next week. And you got 2 weeks to decide whether you want to comment, and hopefully these tools will help get you there if you decide that you do. You know, the other thing is I'll just note that we're on a 3-year pace right now. Every 3 years we get a new bar defense rule. So maybe if we get this one, who knows, we might in 2025 all be back here with yet another rule to talk about. So you never know. With that, Jeff, I'll kick it to you, sir, and thanks, Hope, for going through all that process.
Great. Well, as Hope just alluded to just a few minutes ago, there's some issues with the new rule in terms of reconsideration of claims. And under this proposed rule, it seems like everybody under the free world will be given a chance to ask for reconsideration, to get a second bite of the apple, if you will, except for the school. Everybody else can ask and say, hey, the department, you messed up. You should have given a discharge to a borrower. And why don't you reconsider and look at it again? And for us, that doesn't seem to be all that fair. The new rule, as it's out there, would say that you could request reconsideration if you're a borrower or if you're a state, maybe a state attorney general or some regulatory agency. You could come out and say, well, there's an administrative or a technical error, or you didn't look at a state law standard correct, or there's evidence, new evidence out there, or even if evidence was already there before, but it just didn't get considered by you. And you should look at this. You should change and look at what you did before and come to a different conclusion. And what's worse about this, the borrower or another party can do this for any reason and with no time limitation whatsoever. So you could have a borrower come forward, get denied a BDR claim, and then come back 5-10 years later and say, hey, you know what, I found something else. You know, I want you to reconsider this. That to us is not fair to the school. There needs to be some finality to these decisions. I mean, I can tell you, if you're in court, you get one shot at it. You go to judgment and you lose. You can't come back to the court 5 years later and say, hey, I want to take another shot at it because, hey, I found some new evidence or something's different than what was before. It just doesn't work that way. It's kind of fundamental in American law that you get one chance at something, and when you have a final decision, that's it. We don't come back and revisit it and try to change the result from before. And so that's a fundamental flaw that we see with this rule, is that it's like it's like a zombie. It's just going to keep coming back after you no matter what the department does, and you can't get rid of these BDR claims. Now, we do think that if an institution has, and if you're going to allow the other side to have reconsideration, then obviously the school should be allowed to also. So if a school finds new and relevant evidence likely to change a prior determination, that the ed should consider that, because ultimately we want to have the right decision by the Department of Education, and that should be the primary goal of the claim process, is to get it right. But we do think that there has to be some limits on reconsideration. It has to be a basis. There has to be something material, some relevant evidence that was not available before. It's come to light, and it can be considered by the department. And also, there's got to be some time limit for this, too. And like before we talked about a statute of limitations, there ought to be a statute of limitations, so you can't have these claims lingering 5, 10, 15, 20 years down the road. The same should apply with reconsideration. You just can't have this stuff staying out there forever. So in terms of a comment, we suggest that we tell the department that the process for requesting reconsideration should be afforded to schools, just like if it's going to be applied to anybody else, and that you define the terms and the circumstances under which you can get reconsideration. Even in court, sometimes people will try to go back and ask a court to change a ruling, there are bases for that you could do so. You just can't come back in and just say, hey, you got it wrong, Judge, or I want to change, I want to offer this argument, this and that. Because the problem with that is that the case never ends. And so the same concept applies with the BDR process. At some point, you have to have some finality with this, and the department ought to announce standards on reconsideration as to when you can get reconsideration and when that process has to become final. And with that, I will turn it back over to Aaron, who is going to talk about the discharge relief under the new rule.
Yeah, so we've just hammered this rebuttable presumption throughout. You could tell we don't like it very much. I mentioned earlier, it would require the department essentially to assume that the borrower was harmed by the underlying act or omission of the institution in an amount equal to his or her entire loan. Absent, and this is the carve-out I did want to talk about a little bit more, absent preponderance of the evidence to the contrary. So there is some option in theory to rebut the presumption, but I want to be clear, while the department has the option under the proposed rule of considering whether the act or omission caused the borrower harm, and as such, that the amount of discharge should be reduced or denied, the department's not required to exercise that option. It says the department official may consider whether there is any preponderance of the evidence to the contrary. So first you've got the assumption that the borrower was harmed to the full amount of the loan, and then there's an option for the department to consider whether there's a preponderance of the evidence to the contrary, but not an obligation. So again, as written, the department's not even compelled by the law to discharge the entire amount of the loan and need not make any determination regarding whether the borrower actually reasonably relied on the act or omission or suffered any harm, even if relevant evidence may be available. So just to recap, the proposed rule also doesn't guarantee institutions an opportunity to submit evidence regarding whether that presumption of a full discharge should be rebutted, and that's when they have an opportunity to participate in the process. Remember, if the claim is a prior ed action, this is what I was talking about earlier, then institutions have all that process deficiency that Hope talked about. That's only if you even get a chance at some process. If it's a prior ed action, you're frozen out completely. Right? But if it's one of the other 5 of those 6, then presumably you would at least have some opportunity to participate in the process. But even then, you're not guaranteed an opportunity to submit evidence regarding whether that presumption of a full discharge should be rebutted to provide an opportunity for an institution. You don't have an opportunity for an institution to submit evidence regarding the amount of harm experienced, and there's nothing obligating the secretary to provide the institution with a copy of the written decision setting forth the amount of the discharge granted. I want to highlight that too. Hope spoke earlier about the written determination, just in general. There's a different place in the regulation where it talks about the secretary providing the borrower and the states, if they're involved, with a copy of the written decision setting forth the amount of the discharge granted, so specific to the harm determination. And again, there's nothing in there about providing a copy to the institution. So what's our suggested comment? That the proposed relief standard should be revised to require the department to make a determination of material harm to the borrower and to consider any relevant information supplied. They should be obligated to consider any relevant information supplied by the institution concerning the appropriate amount of relief. So you should get a chance to provide that evidence. It should be guaranteed, and they should be obligated to look at it. Lastly, we're going to talk about recovery actions here. Oh, that's not true, actually. There's one other section after this, so we're getting close, though. Under 685-409, the current processes governing recovering actions, I mentioned this at the top. This is another really important, it's all important, but in my mind, the retroactivity Jeff talked about is critically important. If you can comment on that. I think the prior ed actions piece is extremely problematic, and I think recovery actions is another place where it's, you don't have to, this isn't you're not going out, overboard with this comment. This is an extremely reasonable comment. So the current processes governing recovery actions were put into place by the Obama administration on January 19, 2017, again, the night before Trump was inaugurated. And they were designed, and this is a quote from the Federal Register, right, from the Obama administration's Federal Register. The purpose was, quote, to determine the validity of borrower claims the department asserts on behalf of borrowers and group claims against open institutions, because the Obama administration had two different processes, one for open schools and one for closed schools. But if they were going to bring a group claim against an open school, they were required to go through these procedures, which are significant and robust and, offer motion practice and witnesses, and everything happens in front of an administrative law judge. Those same processes were also to be used to hold institutions liable for losses on claims, and to recover from an institution for losses from bar defense claims. So I garbled that a little bit. Let me just be really clear. So the procedures in Subpart H, the stuff that the Obama administration put out in January 2017, it really had two purposes. One was everything happened in front of an administrative law judge, right? And there's a lot of process here. One was if the department was bringing a group claim, right, then the ALJ, both the determination of whether or not the institution was at fault and whether or not to make a discharge and whether or not the institution was ultimately going to be liable for covering those amounts, all that happened under Subpart H in front of an ALJ. Those same processes were also used even in individual borrower claims, though the adjudication, the initial adjudication happened in front of department staff, the recovery proceeding happened under this Subpart H. So whether it's a group proceeding, in which case the whole thing happened under Subpart H in front of an ALJ, or an individual proceeding where the recovery piece happened in front of an ALJ. In both cases, before the department could recover against a school, you went in front of an administrative law judge, right, and you had a really robust set of process. So the department here is proposing to strip that out. But they've been extremely unclear about what's really happening. So they indicate in the commentary that they would remove 66887, which is borrower defense and recovery proceedings. That was the primary piece the Obama administration inserted into Subpart H about bar defense. Interestingly enough, it's not all of it. It's kind of sloppy here. The department doesn't actually scrub out everything relating to bar defense claims that's in Subpart H. They just delete this one section. I mean, it sort of feels like this was something they thought up at the last moment, sincerely. So first of all, they say, we're just going to kick out 66887, but they don't scrub the rest of Subpart H and take out everything that relates to bar defense claims that the Obama administration put in back in January 2017. And then they say, right, what we're going to do is we're going to replace it with this general framework that we're going to put into 685-409. And this general framework is going to be for the department. This is the framework the department would use to attempt to recover from institutions, right, any amount that the secretary discharges, whether it's an individual or a group process. So let's be real clear on what's happening here. The department, what they're saying is, and again, it's pretty sloppy the way that it's gone down. I don't mean to be critical, but it kind of is. They've deleted this one section out of Subpart H, and then in the commentary they say, here's what we're doing. We're not going to send stuff over to Subpart H anymore. First of all, whether it's an individual claim or a group claim, everything will be managed by departmental staff, and that'll just be decided right here at the department. And then there's going to be a recovery process, but instead of going to Subpart H, you're going to have your recovery governed by this 685-409. And then in the commentary, they suggest that they're actually going to move it, and it's going to, I misspoke earlier, in fact, I apologize. Under the Obama administration, I apologize for this mistake. Under the Obama administration and the current rule, it goes to Subpart G. I misspoke. And so what this administration is saying is, we're going to, everything else is accurate. We're going to decide the claims, whether it's group or individual, at the department, and then instead we're going to send it over to Subpart H. Sorry about confusing G and H there. But here's the thing. None of this is in the regulatory text. Again, it's sort of like the retroactivity stuff Jeff talked about, right? It's not in the regulatory text at all. So what the department has really done is they've deleted 66887, the primary stuff the Obama administration put into Subpart G. Again, sorry for the confusion. They've not deleted everything out of Subpart G that the Obama administration inserted. And then they said that they're going to direct recovery proceedings in the future to Subpart H, which is where program reviews are managed, but they don't actually put it in the regulatory text. So what we've really got is a proposed rule that deletes part of the old stuff, but not all of it, says they're going to do it under a new section, but doesn't include that at all in the regulatory text. It's extremely confusing and not fully formed, and it's a major problem for institutions because as this stands, once this new rule went into effect, at least based on the actual regulatory text that's in this proposed rule, it would be utterly unclear where recovery actions take place. All that's really clear is that this administration does not want group proceedings to get stuck in front of an ALJ. They want to be able to determine group proceedings, just like individual borrower claims, at the department by a staff member. And then if they're going to try to recover from an institution, rather than going to subpart G and dealing with all those procedures that the Obama administration put into place, they're just going to scooch it under the program review procedures and manage it that way, which ultimately would allow you potentially to get into an ALJ and in front of the secretary, et cetera. But you're losing procedure. I just want to be real clear about this. If you read the commentary, the department makes it sound like they actually say in the commentary, they say, well, we want to take it out from subpart G and put it in subpart H because we think subpart G would be confusing for schools, and this subpart H stuff is something they're more familiar with, et cetera. They don't talk about the fact that you're losing process. You're losing the opportunity in a department-initiated group proceeding to start in front of an administrative law judge, which is a significant loss. Instead, everything's just being determined by a staffer. And then the recovery proceedings, instead of going through subpart G, where you're in front of an ALJ and you've got motion practice and witnesses and all those things, instead it's treated like a program review. So the department issues a program review determination, says, yeah, we got a finding that you did everything wrong, and now if you want to contest it, you can go in front of an ALJ, but the program review has already decided that you did something wrong. I think this is a significant loss, what they're proposing, but even beyond that, they have not actually proposed it in the regulatory text. Most of the proposal only exists in the commentary. What's in the regulatory text is truly half-baked. So my strong recommendation is that institutions urge the department, first of all, to require that group claims brought by the department still be adjudicated by a qualifying hearing official. That's what the Obama administration did. That's what the Trump administration did. That's what this administration should do. It's appropriate. If you're going to essentially create a class action, we should have a qualified hearing official overseeing this thing, not a staffer at the department. In addition, they should specify in the regulation that recovery proceedings will be carried out pursuant to, our preference, I think, would still be to stay in subpart G. But even if it's going to be in subpart H, the regulation needs to specifically say that, because right now it says nothing. All they've done is deleted some of the old stuff, and they put nothing in the regulation that indicates or guarantees that recovery actions will move under subpart G. You guys can tell I'm revved up. I'm pretty revved up for Friday at 5 p.m. Submission of arbitral judicial records, 685-300. So we're stepping away from the claim process. This is the very last thing I wanted to mention. You guys may recall under the Obama administration, they inserted, and this really happens in the sections of the law where the department is talking about class action waivers and pre-dispute arbitration agreements and that such, which we're not covering in this webinar for the most part. Others have done a good job of covering that. I know on the career school side, CQ has covered some of that and talked about it, and elsewhere others as well. But we did want to highlight this because we think this is significant for everybody, including traditional institutions of higher education. If there's any one thing that you guys might want to sink your teeth into, even if you don't want to mess with all the claim process stuff we just discussed, which I sure hope you will, and I hope you'll talk with your friends and blow up NACUNet and get traditional higher ed engaged in this thing. But even if that doesn't happen, I think you guys would be interested in this, right? So as a condition of continued participation in the Title IV programs, 685-300 is basically a program participation agreement for the direct loan program. So, there's another section, 668-14, and this one that sort of together say this is the stuff that has to be in the program participation agreement that schools sign, right? So the department is saying we're going to augment your PPAs, basically, and as a condition of continued participation, on a go-forward basis, the department require all institutions to submit a wide range of records, claims, complaints, counter-complaints, dispositive motions, judgments, in connection with any bar defense claim filed in arbitration by or against the school, or in a lawsuit by the school against the student or by any party, including a government agency, against the school. Now, when you first read that, you might say, well, that's not a big deal. We don't have borrowers filing, lawsuits or arbitrations alleging that they should get their loans discharged. But that's not really what this says, right? A bar or defense claim means an act or, and this is in the proposed rule, would mean an act or omission that is or could be asserted as a bar or defense. So if you have a student who sues you in court or tries to compel you to arbitration, should that happen, and any part of their complaint includes a claim that could be asserted as a bar or defense or a basis for a bar or defense, then you got to report that to the department. Doesn't matter if it's frivolous, doesn't matter materiality, doesn't matter how much they're claiming or what they're asking for. You got to submit it to the department right from the get-go and keep them informed. And because the department is expanding significantly what could be asserted as a bar or defense, you're going to capture potentially a lot of different claims, right? So you got misrepresentation, substantial misrepresentation. But, oh, by the way, the department specifically says, look at this second bullet. If the complaint by the student includes an act or omission that is or could be asserted as a bar defense under, and the department specifically says the 94 rule, the 2016 rule, the 2019 rule, or the proposed 22 rule. So it's not just the 6 new standards, it's anything that's ever been a bar defense standard under any version of this rule, right? And remember, under 94, it's any act or omission that could give rise to a claim under state law. So ostensibly, if a student sues you or arbitrates, and they're asserting something that could give rise to an action under state law, which is the 94 standard, now you got something you got to report to the department, right? Misrepresentation, substantial omission, breach of contract, judgment, prior department of action, or any act or omission that might give rise to a claim under state law. If there's anything they're asserting that could fall into one of those categories, you've got now a lawsuit or an arbitration that you've got to report to the U.S. Department of Education. And this covers every public institution in the United States, from Ohio State on down. This includes every private nonprofit from Harvard on down and every career school or proprietary school. This is everybody that would have to start reporting this litigation. I don't care how big your system is, who you are. You're covered by this rule. There are no carve-outs here, right? As written, the reporting requirements are extremely broad and likely to require the monitoring and reporting of most litigation and arbitration involving students. I mean, you got to at least make a call. So you're going to have to monitor all your arbitration litigation to see if it's something you have to report to the department. Also, I want you to think about this. What this rule is doing is it's creating a mechanism for notifying the department every time you have litigation or an arbitration that might include something that represents a bar defense claim. So now you've thrown a flag for the department, and under this proposed rule, remember, the department can initiate a group without any borrower ever actually filing a bar defense. So you send them a flare that says, hey, we've got litigation over here, and it might include a bar defense claim. Maybe the department looks at it and says, yeah, we think that is a bar defense claim, so now we're going to initiate a group process, right, and take it from there. And in that group process, remember, they don't have to establish that anyone actually relied on it, because there's an assumption of actual reliance, or that anybody was actually harmed by it, because there's an assumption that everyone who's in the class that they certify is harmed to the full amount of their loans. So we suggest that the reporting requirements, your comment should be that the reporting requirements should be revised to only require the reporting of final arbitrations and judgments involving a determination. First of all, so you're only reporting a judgment. Because right now, you got to report anything that's even asserted. Just the initial complaint has to go into the department without regard to whether it's frivolous or there's actually a judgment. What we're suggesting is, okay, if the department's going to require you to report, let's make it a final arbitration or judgment involving a determination that the institution engaged in an act or omission that would otherwise constitute a bar defense claim, and that the borrower suffered some harm as a consequence of that act or omission. Okay, here's your 4th secret word. We're only going to spend 30 seconds or less on it because I want to make sure to get to these last few things. So it's statute. The secret word is statute. So please click the radio button next to the word statute so we can make sure that you get everything that's coming to you, as they say. All that CLE credit. All right. Again, I'm taking a deep breath. I'm very passionate about some of this. Some of you know, my father was a university administrator for 40 years and a president for 23, and my mother was a professor of music. I grew up on a college campus, and I had committed my entire career to higher education. And my concern is right now that there are people inside the department who really do view higher education as the enemy. And I don't agree with that. To the contrary, I believe strongly in higher education in the United States. I think it is maybe the greatest export that we offer to the world. And I'm troubled by a rule that I think is providing extremely short shrift to institutions and very clearly treats them as the enemy at best. And so, again, I hope that you guys will, if you find something here that's helpful, that you'll comment. All right, so the last couple of things, we got our borrower defense rulemaking timeline. I mentioned at the outset, this goes all the way back to 94. We've got all the major pieces here throughout from 94 to present, and all of those links are live links. So if you want to look up any of the federal registers, including proposed rules and final rules, if you want to see that 95 notice, all of that stuff, you've got links here. There's also a little bit of litigation, links to a little bit of the litigation included. I will just reference again, we did something kind of like this for Title IX 2 weeks ago, because there is a proposed Title IX rule out there right now, right? We've got 3 comment periods running simultaneously. This presentation from July 7 right now is free and available online, and we break down the new Title IX rule and talk about some of the stuff there that you may want to comment on. Also, we've got a Title IX training series if you're still trying to comply with the current rule. And finally, please check out our blog. We're writing about stuff all the time. I think we're going to write a little bit about, a little more about bar defense next week. We've written a little bit about the sweet settlement and other things as well. All of these presentations are available online and free and on demand at our TCLE library, which is pretty easy to find. If you ever want to find something and you can't, please just give us a holler and we'll make sure you find it. And then finally, we've got some white papers that we have put out last year and probably will update. One of them is about financial responsibility reporting. There's another about 90-10 and another about private institutional loans, things along those lines. So keep an eye out for that kind of stuff. And then lastly, we're not your lawyers unless we're your lawyers. So let's get to questions. We've got, I think we got a good 10 minutes or so, and we do have a few. So I'll scroll back here and start at the beginning. So one person's asking, do we know of any parties, attorneys, plaintiffs' attorneys, et cetera, who have submitted a claim for something like omission where it might be immaterial? What I would say in response to this, I mean, we've talked with a lot of other folks. We've personally responded to a few hundred bar defense claims out of our shop, and there are all kinds of claims that are out there, and the quality of these claims that we've seen from borrowers ranges widely. I think there are, without question, claims that have been filed that have merit, if not tremendous merit. We've also seen claims filed that, clearly someone was provided with a form. We've seen some where the forms aren't even filled in, where it says something like, my school named, and then there are brackets and a blank, so there are folks out there supplying borrowers with forms and encouraging them to submit. So we've seen the gambit, and I think, my expectation is that there probably have been almost certainly borrowers who have filed complaints alleging that schools did not tell them something, and in some cases, my expectation would be those have merit and some they don't, meaning that they are probably not material but immaterial. Jeff, you've seen a lot of these. Hope you as well. Is that a fair statement? Fair summary?
Yeah, that is. I mean, in terms of like an omission, it could be an omission such as that you didn't tell me my credits wouldn't transfer to another school. I think we've seen that before. But typically it's something affirmative, though, that the school has said, either about like accreditation or they're promised certain things and that the school didn't fulfill it, as opposed to an omission.
Yeah. Agreed. And look, I mean, there are hundreds of thousands of these complaints out there. So, they vary widely. I think, the department's trying to solve 2 riddles right now. It's interesting because I think they've been trying to solve both of these riddles with the same solution, which is probably not possible. The first riddle is, what do we do with the backlog, the hundreds of thousands of claims that we have from, ITT and Corinthian and these big school groups that are now closed? And then the second riddle is, well, how do we devise a claim process for managing future complaints from all institutions of higher education, or impacting or alleging conduct on the part of all institutions of higher education? And unfortunately, I think those have been conflated, right? So you're trying to create a process in part that you can utilize for the expeditious adjudication or discharging of all these old complaints, and then you're trying to devise a process simultaneously that is also sufficient and we would hope provides sufficient process for future claims. Again, I think part of me almost wishes they would approach those separately. And I guess in some respects, maybe the sweet litigation that's floating around out there kind of is doing that. But it's a real riddle that the department's been trying to solve, and I think it's been driving a lot of the creation of a process here that, in many ways, is I think designed to make for the easy and expeditious adjudication and discharge of loans. You don't have to go in front of an ALJ. You don't need borrowers who've actually filed claims. You don't have to allow the institution to participate in every instance. You don't guarantee them a bunch of procedural rights. All of that allows you to process, adjudicate, and discharge loans more rapidly. But it doesn't necessarily increase the likelihood of just outcomes. And I think certainly on a go-forward basis, without regard to dealing with all these past claims, certainly sort of present and forward, we want something that's designed to adjudicate claims and get to the right answer. Okay, another question. Sorry for the speech. Let's see. Given that the statutory language allows the department to specify which acts or omissions of an institution of higher education a borrower may assert as a defense to repayment of a loan, has the department explained or been forced to justify how it can simply apply borrower defense without the borrower asserting some complaint as a defense? If the borrower hasn't asserted anything, under what authority can the department discharge? Well, we agree. I mean, we think the Obama administration, spoke to the idea of being able to bring a group claim. I think that's, their rationale is discussed a little bit in their preambles. Here, I think that there is some discussion around that. But that doesn't change the fact that, we've obviously said in this presentation, and we agree, we think it's an overstep. And if push came to shove, I mean, we think that there's a real chance that a federal court might agree that, agencies have a fair amount of discretion, right, under Chevron and all these other decisions over the years that have spoke to that kind of thing. But there still has to be sufficient statutory authority. And, we agree, right, that certifying and prosecuting group claims without any underlying borrower ever having filed a complaint is a problem. We also think, sort of, as we said, delegating the authority to states to bring claims without a borrower ever bringing a claim is fairly extraordinary as well. Jeff, Hope, thoughts on that front?
Yeah, I mean, I just echo what you said, Aaron. It just seems like the department's going out of its way to try to find excuses, trying to create BDR claims and give discharges to borrowers when the borrowers aren't even standing up for themselves. Just kind of an odd process.
Yeah. Do you think the use of early action admission, typically requiring an enrollment decision from a student before considering other options at other institutions, could constitute aggressive and deceptive recruitment? Well, look, we didn't spend a lot of time talking about this definition of aggressive and deceptive recruitment. And just because we don't have enough time to get to everything, right? We had one slide. But we highlighted a couple of three of the things that are included in that slide, like not responding to requests for information, for example. And one of the reasons we highlighted that is because we thought, well, gosh, I mean, are you actually saying that if a member of the public, because that's what a prospective student is, if any member of the public requests information from the school and they don't respond, that's deceptive or aggressive recruiting? I mean, there are a lot of places in that definition where we think it's going to be extremely hard for institutions to actually operationalize compliance protocols because the standards are so vague. And one of the things you could consider doing, if you really have an appetite for this kind of thing, is going and checking out that definition. And we think, again, there are several examples where they use words like, well, you can't pressure a student. Well, what does pressure mean? I mean, doesn't every admissions personnel who believes in their school, and maybe they're an alum, a lot of them are, and says, oh, it's a great school, we think you should come here. I mean, someone could say, well, that was pressuring me into enrollment, right? And I think the department would say, well, we would never do that. But I don't think, being the risk-adverse, suspicious attorney types that we are giving this presentation, I think it makes us awfully nervous when the department just says, well, trust us. We think we would prefer to have concrete standards, and I think you need concrete standards, things that have a little more nuance so that you can, again, build controls that actually make sense and will give you some confidence you're not going to violate the law. So all of this is to say, I think that's a great question. And I think an aggressive regulator could say, requiring people to make decisions, because one of the things in that definition that they really don't want folks to do is to create urgency or immediacy or to, communicate to students, you've only got so much time to enroll, right? But what if you said to somebody, if you don't participate in our early admission and accept now, it reduces the likelihood that you'll be accepted? I don't know. Is that pressuring someone? So I think there are things to be concerned about in that definition, and I hope that you guys will take a look at it. And I think this questioner raised a really nice example of that, where there could be some question. Let's see. There's rightfully much focus on recovery actions, but the department seems to recognize the legal difficulty or recovering based on relief provided under new reg standards. Should we not also be worried as much or more about what the department may use the extensive relief that they intend to provide under the proposed new BDR reg as a basis for other action, such as limitation actions or denying recertification? Yeah, it's interesting. I mean, this is a great point. I guess in my mind, what this is sort of getting at is that when you have bar defense claims, pending or adjudicated, that can potentially trigger there's regulatory collateral. It can trigger other things. So, for example, the department has proposed in their financial responsibility rule, that proposed rule isn't actually out, but the drafts that we saw during NEGREG, included as financial responsibility triggers if you've got a significant number of claims that have been filed against you and are pending. Well, wait a minute. I mean, that doesn't even require that they've been adjudicated, right? So if the department makes it really easy for people to assert claims on their face, and sometimes the department will say, well, that's not a big deal because, to recover against you, you've got this second proceeding. And a lot of schools have said, well, wait a minute, it is a big deal if you make the claim standards low because then people can file claims. And even without reaching an adjudication or a recovery action, the fact that we've got claims out there that are pending, one, there's reputational harm. But two, there's also this regulatory collateral because there are these other mechanisms in the department's regulations that potentially get triggered. And that's one, for example, they proposed where if they make it really easy for people to state claims, remember we talked about breach of contract, there's no materiality standard for breach of contract. You can state a valid bar defense claim on its face without regard to whether or not the breach was material to the school or the borrower was harmed materially by the breach, right? That's still a claim on the record. So if you get 1,000 students that make those claims, even if they've never even been adjudicated, if the department gets what it wants in its proposal around financial responsibility, or what we expect will be in that proposal, then that would trigger a financial responsibility problem. And the department could then turn around and require a letter of credit. So I totally agree with this question. I think it's not just about the recovery action. And what we hear a lot out of the department when they talk about making it easier to accomplish adjudications and discharges is the schools shouldn't care up to the point at which the department's trying to pursue recovery. What's going on before that, the adjudication between the department and the borrower, doesn't really have any stakes for the school. That's all about the borrower. And that's, in our opinion, completely false. What's fascinating is, in the NEGREG, the department actually makes the statement, well, we have no evidence that schools have been suffering reputational harm. First of all, I'd love to know what kind of study they did or analysis to come to that conclusion. Or if they're just saying we have no evidence because we've never looked for any evidence, right? But our clients and the the schools we've talked to certainly take the view that having a bunch of bar defense claims lodged against them causes reputational harm. And even beyond that, again, there's the collateral regulatory harm that could result if the department says just the presence of these claims enable us to take other types of actions. And then the last thing is, even if there are claims and adjudications that ultimately the department does not pursue for recovery, what's to stop an attorney general or a legal aid group or a plaintiff's attorney from saying, I don't care if the department's trying to recover. What I do care about is that they have adjudicated and determined that the school engaged in misconduct. So again, there are real stakes for schools, even at the adjudication stage. And we think it's really important to comment on that and to try to impress that upon the department. All right, I think we have time for one more question. Oh, some of my questioners. Okay, any additional examples of consumer violations that could give rise to a bad program review violation Well, first of all, I don't think it has to be bad. That's part of my point here is, remember, the department assumes harm and assumes reliance under this proposed rule. So part of my great concern is it could be any consumer violation. I mean, the department could say, we think you flubbed when you calculated outcomes or placements. We think on your external website, and by the way, this is included in their new definition of misrepresentation. They've expanded that definition, and they make explicit. They say, look, like if you're calculating, if you fudge information to create higher rankings, and I think that's clearly a shot at traditional higher ed. But they also say, let's say you've got some sort of success rate on your website, and it turns out that that success rate is not accurate or doesn't account for certain things that they specify, by the way, in this proposed definition. They might say that that's a consumer information violation. They might say, well, we think you were providing a success rate that, here's a great example, and I'll leave you with this, but this is another reason you should also look at this proposed definition of misrepresentation. The department says, when you calculate employment rates, you should be excluding anyone who was employed at the time they got to your school. First of all, as an observation, I have a pretty high level of confidence that the employment rate statistics that are on the college scorecard do not consistently take into account whether or not those students were employed on the day they started at those institutions. I don't think that data point exists. What that means is, I think that the college scorecard probably theoretically is violating this rule, because what the department is saying is, if you got an employment rate, you got to exclude, you can't include folks who were already employed at that employer before they started school, right? A lot of institutions don't take that into account. You may not even have that data point. Also, interestingly, I think there are accreditors that don't take that into account, right? But what that means is the department could come along in a program review and say, oh, we see you got this employment rate or success rate that you publish. Are you excluding folks who were employed on the day they started at your school? Or if they graduate and go back to that employer, are you including them in that success rate? And if you are, that's a misrepresentation by definition under this proposed definition, right? And someone could reasonably rely on that to their detriment. Doesn't matter if they did. That's a substantial misrepresentation. Now the department can certify a group. And if they bring it up in a program review, you don't even get to participate in the process. And there's no requirement that the individual borrowers file a claim or that there's any demonstration that anyone suffered actual harm or actually relied on it, the misrepresentation, right? Scary stuff, guys. I mean, scary stuff. You probably don't need me to say that. I hope that this has been helpful and that you're finding that there are things here that may be of interest to comment on, and that some of these materials may help you in marshaling those comments. I will say, if you decide to comment, if you can individualize the comments, if you can talk about how they affect your institution, that's better. You can copy and paste what we've put in here, but the department has software. If 1,000 of you copy and paste our comment, they're going to read it once, right? So you do get better ROI on your comments if you can talk about them in a way that is somewhat individualized, or present them in a way that's somewhat individualized, and you're not just copying and pasting our comments. Again, you're welcome to do that, but just keep in mind you'll get more ROI on those comments, return on the investment, if you take the time to individualize them, even if ultimately they say something similar. And if you have questions, as always, we welcome you to give us a holler, because we think this stuff's important. Be well, everybody. Enjoy your weekend. And if you need anything, just let us know. Bye, everyone.